Hey, it's your old buddy Brian Parker doing another fantastic, exciting video. This one is going back to our roots. We have a debt buyer lawsuit. It's a recent case I'm currently litigating. And you know I like to do actual cases in my videos. I think I don't take the approach that I'm just going to tell you what I think you should do. I'm going to show you what I just did, and hopefully you can use it in your state, in your facts. This is a case against U.S. Management Incorporated. They're a student loan debt buyer. It's all the same stuff. If it is a debt that you're purchasing, it doesn't matter that it used to be a student loan or Citibank or a promissory note. It's a debt, and they will take it one step further and say it's really an account, because it is under the securitization of it all. All you're really buying is an account, or as they say, evidence of some indebtedness of certain receivables. I kid you not, that's the language that I see and you will see that is taking the shape of debt, which it's not. They're not indebtedness collectors, they're debt collectors, yet you will see no word debt in any of the following or most debt buying lawsuits. So check that out, use that to your ability. Four things I want you to remember today. Break down the lawsuit and the supporting documents. Identify the linchpin in the lawsuit. You know I love the linchpin, and I want you to love it too, because you take a large situation, you go, for the want of a nail, a kingdom was lost. Find that nail, eliminate it, and you eliminate the lawsuit. Find the linchpin. Number three, what's the proof of ownership? They got to have proof to have what's called standing. Number four, proof of the amount owed. Okay, you claim you owe it, and you're claiming I own it, and you claim I owe $30,000. What is in that $30,000? How did it get to $30,000? That's a common question I hear from clients every day. I go, suddenly I'm being sued for $6,000, and I already paid $5,000 of the $6,000 debt. So you have a right to ask that, and that is part of standing and ownership. So I have done a lot of private student loan videos for you. Here's a couple. There's a couple floating around. I've also done some linchpin videos. They're all the same. They're focusing on debt buyer lawsuits and what's the linchpin that knocks out the debt buyer lawsuit. It's always just one or two paragraphs. If you knock out those, you knock out the case. So number one, you're going to look for proper documentation and assignment proof. Are you being sued for breach of contract? You violated the terms and conditions. Where's the contract? Commonly, they will attach a facsimile. That word has changed the meaning, but something that is designated to look like the contract, but it isn't. Look for your name, look for your signature, look for the date when it was printed. On the bottom of most contracts, it'll say, copyright 2016. You took out a debt in 2014. Clearly not your contract. So that's stuff that you have to look for. In this case, it's the Sallie Mae Bank debt that they claim to have been assigned, they meaning U.S. management. There's no evidence of that in this lawsuit. But again, they're banking on the 90% theory. What is the 90% theory? It's statistically, most collection lawsuits die a death 90% of the time, either through default or early settlement, before you get to the point of someone doing something about it. People just want to stick their head in the hole. There's nothing you've been through that I haven't been through myself in my life. I understand the sticking your head in the hole ostrich theory. It's a way to deal with something, but it's part of that 90% reason why they take no care in their complaint. So you be the 10% educated, strong people that you are, and use my tools and techniques to expand that 10% so you can go after them while they think they're going after you. And one way you can do that with a Sallie Mae Bank lawsuit. Sallie Mae and Sallie Mae Bank were actually part of the same organization called Sallie Mae. And they broke up in 2013. Sallie Mae Bank took its possessions and went. And Sallie Mae, I think under government prompting is what I'll say, changed its name, perhaps rather than change its practices, it became Navient. So Sallie Mae Bank debt is floating all around there. So let's look at the Sallie Mae promissory note, common in these U.S. management cases, Shazam, and you can see it says lender Sallie Mae. Why do I care? Because Sallie Mae is not Sallie Mae Bank. At the time this was created, it actually says on the bottom, 2010 to 2000 to 2013, that was prior to the breakup. This debt was created and it was either with Sallie Mae or with Sallie Mae Bank. Remember, in this case, and you should look for this in your cases, if Sallie Mae Bank is the original creditor, says right in their promissory note, Sallie Mae is the owner, or in this case, the original creditor or lender, and let's remember the Salt Lake City. So in that same document, you'll see they have what's called a governing law provision. The governing law provision looks like this, Shazam, and that is just telling you if a lawsuit should occur, you have the right to expect that, and well, let me read it for you, and that would be the lender, remember we just said who the lender is, located in the state listed for the lender on page 1. And we looked at that, and it was Sallie Mae is the lender, Salt Lake City, Utah, in the introductory paragraph of this note, and the note will extend into the same state. Consequently, the provisions of the note will be governed by federal laws and laws of the state to the extent not preempted without regard to conflict of law rules. So it's a Utah case if it gets filed. This is in no, it isn't. This is in Michigan, this case. So they've already breached their own contract, which this is a breach of contract case they're alleging that you breached. The other terms included are the assignment provision. Let me put up the assignment provision, Shazam. And that's telling them that we're going to assign this. We're not going to ask your permission. So what is important in that information for you is that just about all these education loans, private, and a lot of public loans up to 2010 were put into secured trusts, education loan trusts. In the private side, it was called a SLABS, a student loan asset-backed security. And once it's in there, it gets sold by whoever owned it, Sallie Mae or Sallie Mae Bank. The new owner is Bob Johnson Trust or Sallie Mae Made Up Portfolio Trust with Deutsche Bank as the trustee, meaning the debt is no longer owned by the lender or the creditor. So Sallie Mae in the lawsuit that you're going to see can't be the creditor they're claiming they are to have given it to my plaintiff. In this case, it's U.S. management. So you have to look for their language, your linchpin, and who's selling what to whom and why. To see if you are part of a secured trust, which is 99 times out of 100, use EDGAR. Let me put up the 3 ways to do it, Shazam. Look at the EDGAR search. The U.S. Securities and Exchange Commission has a great database for you to go check, see if your loan and loan number is in a secured trust. Number 2, Bloomberg has lots of fancy ways to use their data. And again, you can also buy an audit or a subscription-based service to go find whether your debt, student loan debt, was securitized. And I would argue just about yes, it is. But if you can have the information, it's even better. Big linchpin is the assignment. You have got to show that your debt was assigned. Well, they're showing it for you. They're saying Sallie Mae Bank sent it to the plaintiff in this case. Let me put up the 2 counts alleged against my client, Shazam. And that's 2 counts of 2 debts. My client assures me she did not have 2 debts. And the linchpin here is 7 and 8 and 13 and 14. And they both say the same thing, which is the contract was duly assigned in the normal course of business. Plaintiff and or its assigner completed performance under the terms conditions of the contract. On a basic human level, I sell you my car. Brian sells you the car for $500. Here's the VIN number. You are the new owner. I am the seller. You should say that if you own something. There's no ambiguity. You don't say the contract was duly assigned in the normal course of business. What is that? And to whom? And when? And why? That's quite clear to me. If I own something, I can tell you exactly who sold it to me and when I bought it and why I bought it. Plaintiff and or its assigner. Which one? If you own it, you are just the plaintiff. You don't need to put and or its assigner. You know all the information. So clearly they don't, and it's securitized in the slabs. But you've got to take all that information, purely human information, and dump it into your counterclaim. Your counterclaim, your counter affidavit, which will end up on your counterclaim, which will be part of your answer, which will be part of your affirmative defenses. I'm doing this new thing now where I attach it to my answer. No answer leaves my office without the counter affidavit. It's just, it's a little nice thing that goes with you, with your answer, with your counterclaim, with your affirmative defenses. You have a motion filed against you. I don't own the debt. So, and here's why. You get interrogatories come your way or discovery. You go, well, these guys aren't the real owners, as I said, pursuant to my counterclaim, and here's my counterclaim, and here's why. That little document follows you so do a little work, and it'll reap great benefits. Here's some videos on my website. Here's account stated statute videos, killer asset-backed accounts. I don't want to say what the word is. I'll say it's ass. Account stated statute video, how to write a killer affidavit, how to write a counterclaim. I've got a free PDF on there video showing you how to do it for free. On there, I say my membership website, collectionstoppersolutions.com. 260 videos, tons of word templates that you can just fit your facts and your state law into. It's a good way to start. On the membership site with this video will be an answer to U.S. management lawsuit, a counterclaim against U.S. management. What do you know? You got that too. I'm going to give you 2 counter affidavits for you to use as word templates, get you started, to use in your case. Rock Creek student loan answer. I'm just going to give you another answer on a different debt buyer, but they all really address the same issue. What is the issue? Using their own documents against them. Have you heard that before? Do they have standing? So to show that, you'll have my show notes too attached to the video. That's this pile of stuff. If you don't want to look at this face again, you just want to read about it as it's going along. And I'm going to give you a validation letter. Stay tuned. A free validation, my latest validation letter you can have for free. Just stay tuned when I get to it after reading the notes here. So you're looking at that documentation. In this case, I showed you the first page of their promissory note that says Sally Mae owns it, not Sally Mae Bank. That's why I told you the information about Sally Mae and Sally Mae Bank. That's important. That goes into your counter affidavit. This is even the right creditor. Here's their loan paperwork specifically stating. If you want to do a little research and put Sally Mae Bank, when did they break up with Sally Mae? It'll come up in 2013, they went this way, they went that way, and Sally Mae, a separate entity, became Navient. Didn't change their practices, just changed their name. That's one theory. So you'll have Shazam, a bill of sale and assignment, which is just junk. First and foremost, and this goes into your counterclaim, counter affidavit, and your counterclaim and your answer, your name's not in there. Your debt's not in there. The word debt isn't used. In fact, all they say is these contain certain receivables, judgments, or evidence of debt. That's the closest they can come to saying there's a debt in there. But your name, specifically your account number, is not anywhere to be seen. That's a viable presentation of a defense. If this is a bill of sale of assignment, Your Honor, where's my name? And so they will say, well, there's an additional piece of paper. Look at the Green versus PRA case, plenty of cases that support the conclusion that most cases and courts draw, which is if there is additional paperwork to the bill of sale and assignment, it must be certified and notarized and have an indicia of evidence showing it's connected to the bill of assignment. You can just tell from the clunky words they use in the bill of sale and assignment, nothing's in that thing. And they didn't expect you to come along and have to ask them in an educated way. So the end paragraph says, the bill of assignment is executed without recourse. That means it's absolute junk as is. Hold my nose, you take this, like a baby's used diaper. The debt is useless, And it also says, no other representations or warranty of title or enforceability are included with the assignment. That means it is really an old smelly diaper of a debt, or not even a debt, an indicia of something happened in the pants. It's a worthless debt, if you will. There is a part that says this whole thing is based upon the terms and conditions of the certain, here we go, charged off educational loan portfolio purchase and sale agreement. That's your forward flow agreement that represents the securitization of it all. It's securitized. The debt is long gone into a slab. Ask for that. If you get into the weeds and you feel you're losing, ask for that. You will get that case settled for nice terms. They will do everything not to give that to you. There's a reason. It'll tell you the truth. I can assure you that I've seen many cases, and there's never anything specific in the cases specific to my client's debt being part of any assignment, transfer document. It just doesn't work for their machine of sending out thousands of lawsuits and paperwork that is a one-size-fits-all. Use that to your advantage. You want to challenge the validity of every assignment in your counterclaim, okay? So this all, when you have an assignment, specifically case law says we own the debt, we stand in the shoes of the original creditor or the assignee. So that's a term of art. Someone assigns, they're a assignor. The person that receives the debt or indebtedness or evidence of indebtedness or some certain receivables, they are standing in the shoes of the assignor as the assignee. So it's no coincidence that you have to prove that they have no standing. That applies to the fact they have no assignment. That's a legal term. They have no standing to sue me. They have no interest in this case. And that's the paperwork that we just discussed in a basic student loan collection lawsuit. They're all the same as any other debt buy lawsuit that have been cut up and sliced and diced and securitized. Nobody really owns anything that they're suing you upon. You use their own documents to show this. Lastly, regarding the accuracy of the debt amount they're suing you for, I counsel that you send a validation request. Have them prove, if you get a letter before the lawsuit or you get an inkling that the lawsuit is coming, send a validation letter out to the creditor and also to anybody else that's claiming ownership that you're aware of. And just their responses are probably going to contradict what the lawsuit will say was the original documents. I've seen it 9 times out of 10. The right hand, as they say, doesn't know what the left hand is doing. The creditor, the other entities, the services, all these guys, when the lawsuit is filed by a debt collector attorney, he or she is not taking great care in this. I just deposed a debt collector attorney last week, and he was very clear. He goes, this business is really easy. It's just forms. I'm not going to give this up. It's easy. I'm paraphrasing, but that essentially is the mentality. They're not, and I actually have other debt collectors that have told me that it's an easy job. You just put your 9 to 5 in, keep your head down, do the bare minimum, you get a job and health benefits. So this is your case. So I want you to give it the attention that everything that you own deserves, and you will win if you put your mind at ease and know that they're really not in the business of winning, they're in the business of surviving, but they're in the real business of defaulting. 9 times out of 10 cases, a case will default or settle early. So there's no care. You put care into your efforts and you will win or get a strong discount, because the attorney, he didn't take this job to move mountains. He took the job so at the end of the day, he can go home without thinking about the job and have his bourbon. Nothing wrong with that, but you put just a little extra effort and you'll win that case. And courts will respect that too. I very commonly will be in front of a judge and have to tell them they got the wrong guy or they got the wrong case or the wrong facts. It actually happened today, and my client happened to be in the courtroom, and he says, why didn't you tell the judge that they were saying the wrong things? I said, I'm just going to wait in the weeds. I want them to keep saying the wrong information to the judge. And then when the moment is right, you strike and you say, they don't even know their own client. As you recall, the 3 other times we were here, they said it was ABC debt collector. They got the wrong guy. And that adds credence to what you're saying. So, and that's gray hair, man. You know, maybe 20 years ago, I'm jumping on that judge, he's got the wrong. You wait. You wait. Be waiters, be hard workers, be owners of your debt, and fight them with your care and deliberation, using the techniques I give you if you choose. So remember, attached to this video will be an answer to a U.S. management lawsuit, a counterclaim against U.S. management. I give you those 2 things, again, in Word, so you can cannibalize them and dock them up and place your debt buyer, whether it's somebody, you know, collecting for a Discover Bank, or it's an MCM, a Midland Credit Management, or a Crown Asset. I've got all those videos. I've got Crown Asset Managed video. I've got LVNVV funding. It's probably the most popular in my office right now. Crown Asset. We've got PRA, Portfolio Recovery Associates. We've got them all. We've got UHG. Look at all those videos. Woo-hoo-hoo-hoo. It's just a lot on that website. It's 260 videos. Some of them are duplicated with different forms, different approaches, so that you can manage your case better and be educated and be on top of their case. If you get to the point where you know their case, you're doing great, and it'll come through and you'll get that case settled. And it doesn't take much to know it better than the guy that just wants to do the bare minimum. So also the show notes. That is great help to you if you miss something or don't understand, because I'm a clunky mumbler. The validation letter. See my validation letter, fill it out, send it certified, return receipt requested, and get the info that's going to sink their ship, all right? Keep a copy of the signed letter. Please don't make that mistake that a lot of people do. So you can say, yep, this is the actual letter, not something you pulled off your computer. The actual one, and send it certified, return receipt requested. It'll be attached to the lawsuit, the very latest validation letter I'm going to give you on this. And do it before the lawsuit or even after the lawsuit. Information is power, man. So that's how you handle a debt buyer lawsuit, a U.S. management. You didn't hear me say much about U.S. management other than showing you the clunky complaint. You look for the linchpin of it all. Look for those 2 paragraphs, or 1 paragraph. It's the linchpin. If it goes away, for the want of a nail, a kingdom is lost. If that goes away, the whole bunch of cards, what they call house of cards, comes down. It's true. If they can't prove they own it, and they barely can anyway, they can't be suing you, and they don't have standing. You want to eliminate their standing. They'll help you a great deal. I hope this video helps you a great deal, and you rock and roll and enjoy this. Feel free to add comments, but more importantly, like, love, and subscribe, and we'll keep rocking it out. All right, thank you. Bye-bye.